constitutionalism, third place. If one doesn't understand the distinction among these three phrases, it is difficult for them to understand the nuances of the constitution. The third important point that I would like to refer to is that, unlike the British constitution, though many writers say that our constitution is based on the British constitutional practices, I do not agree with them at all, because right from day number one, it was tried or attempted to define the various organs of the government, and they created an executive called the Governor General. If you look into the Government of India Act 1909, 1919, and 1935, there was not even a semblance of the parliamentary form of government that was and that is being practiced in UK, right? And therefore, if somebody says our constitution is based on British constitutional practices, I think please don't agree to it. And that is a place I want you to develop critical thinking on your own. And that is precisely the purpose for which the constitution was written down. And I think when you write down, you have specifics, you have different phrases used. And as a constitution that came into force in 1950, the framers of the constitution also borrowed provisions of various constitutions, including the British constitutional practice, the Irish constitution, the Australian, right? And also the American constitution. So therefore, one has to understand the nitty-gritty of certain phrases used for a specific purpose, and you cannot totally ignore that these are all to be subsumed by what is happening in England, and so it should happen in India. I think that type of logic is what is being killed. Therefore, the interpretation given by the court from time to time is the ultimate attack that I would like to take, because by and large, I have seen we have bred a team of teachers or a group of teachers who are worshippers of the Supreme Court judgments. Okay, the Supreme Court has said it, so therefore it must be right. Right? We don't apply our mind to look into whether the judgment is right, wrong, for what reasons. And I think every citizen should have, whether one is a law teacher, law student, or a judge, must have this critical thinking to find out whether the court, what it has said, is right or wrong. Right? I'll just give you a quick example. Something which we understand in the nomination of the election commissioners, the judgment, which very clearly indicated, and if you go through the judgment, right, in the judgment it says the petitioners, all the petitions, 4 petitions that were considered together, were public interest litigations, right? It is about the nomination of the election commissioners and the chief election commissioner. And then after writing so many pages, the Supreme Court says the petition, the writ petition, is admitted under Article 32 of the Constitution. We also just read that and go to the class and say like a parrot, right? It is admitted under Article 32. And that is why somebody very beautifully defined what is meant by teaching, right? And said it is translating the information available in a book by the teacher to the students without either of them understanding it, right? The last part of it is very interesting. Without either of them understanding. So when you read it casually, it doesn't stop you from for a second to find out whether the statement is appropriate or not, right? And that is why, as a teacher, as a researcher, I call myself a student, because I know nothing about the Constitution. Because the more you read, the more you tend to understand. The more you understand, you automatically try to question and challenge the views expressed by various players, the political parties, the Supreme Court, the High Court, the President, the Prime Minister, whosoever it is, the ministers, right, and including the public opinion. And that is the level in which we are supposed to act. And therefore, ladies and gentlemen, my first observation is that you should be clear with two important courses in law, right? Both for the teachers as well as for the students. Those two are, one is constitutional law and the other one is public international law. I think Dr. Subramania is there. He will understand the implications, because today constitutional law of any country is probably molded, conditioned by what is happening all over the world. And therefore, it's not devoid of a specific law, but the practices followed by the countries, whether it is in the field of human rights, humanitarian law, international trade law, law of the sea, air and space law. I think you can name many of them. All of them are based on treaty obligations. And those treaty obligations, when they are being translated into action, they become constitutional and statutory within the domestic jurisdiction of each and every state. Having said that, if two subjects are very, very important, and I think in many law schools they have divided constitutional law into two courses. One course is overload of what you call it as the Supreme Court decisions. It is to teach only fundamental rights, and if time permits, the directive principles and fundamental duties in the last 1 hour, or we ask the students to read that on their own, right? So the whole number of classes that you hold in one semester is about what the Supreme Court has said about doctrine of eclipse, what is the judgment, how many judges were there. So we are all glued to what the Supreme Court has said. Of course, I am not ridiculing. If I have to support the Supreme Court has done a wonderful job in the last 75 years in strengthening, upholding, and also substantiating the fundamental rights and freedoms given under the Constitution. I think we have to stand up and salute the Supreme Court for that. But for the rest of the Constitution is not only part 3. There are several other parts, right, which we don't know, right? And therefore, the interpretation given by the court from time to time is also very, very varying. I sometimes doubt whether the court has referred to the constitutional provision or simply they are, from their memory, they have written something, right? And this is what one example I have given you. I have got a couple of examples which I'll try to give you. And therefore, as a teacher, you have to balance the constitutional law courses. When you divide that into two, I'm not saying that you should not speak about fundamental rights at all. But I think limit the fundamental rights part to say around 50% of the classes, and the remaining 50% you also speak about something different, constitutional institutions, right? So I think it requires a whole lot of dynamics in which I think we have to sit together and come out with a syllabus or a course outline which will balance constitutional law 1 and constitutional law 2. Having said that, let me just begin asking you this question. How many of you have read the Constitution at least once in your lifetime? And I'm very confident that none of you would have gone through that even once. Because when you are a student, you don't know what is meant by the text of the Constitution. They all call it as a bare act. It is not a bare act. It is the text of the Constitution. And the teachers also don't bring, also don't want to see anything, and there ends the matter. And when you come to your master's degree, maybe one or two teachers must have told you to look into some specific provision. You would have touched one, the text of the Constitution for the time being, and you would have read it. But I really do not know whether we have read the Constitution from we the people to the 12th schedule at least once, so that it gives us better appreciation. I'm not saying understanding. In one reading, you will not get understanding, but it will give you a picture of what the Constitution literally contains. Therefore, this 75 years of the working of the Indian Constitution, we should give full credit to the Constitution, because if you look around the country called India, all the countries surrounding India have faced some turmoil or the other, irrespective or in spite of having their own constitution. Right? You take it Nepal, you take Bhutan is an exception, Bangladesh, Sri Lanka, right? Pakistan, Afghanistan, Myanmar, right? You just go around the country, you see almost all the countries, in spite of having the constitution, they have faced not one but series of turmoils from time to time. To that extent, the Indian constitution stood the test, right? Irrespective of certain turmoils inside the country, it kept the people of this country together as one unit, and that is the full credit that should go to the constitution, right? But having given the credit, in the last 75 years, we have also, in my opinion, and that is the reason why it is not a popular course at all, right? We have committed 3 Himalayan blunders. I want you to carefully listen to these 3 blunders. The first blunder that we have committed in the field of constitutional law is that we wrote the lengthiest constitution in the world, right? You look at the American Constitution, there are very briefly 7 constitutions. I'm sorry, 7 articles, right? And you can read the full text in about 2 hours or 3 hours maximum. Unfortunately, our 42nd Amendment is lengthier than the American Constitution, right? So therefore, we wrote the lengthiest constitution in the world. Is it a blunder? You may ask this question, because I called it as 3 Himalayan blunders. Is it a blunder at all? Standalone, it is not a blunder, right? Because one country tried to overtake us, right? And they wrote much lengthier constitution than that of India. And today it is not there in the political map of the world. I am talking about Yugoslavia, right? So therefore, writing a lengthier constitution is not a positive aspect. And therefore, in India also, writing the lengthiest constitution is not a negative aspect nor a positive aspect. But the second one, if I tell you the second blunder, possibly you will understand the implication of the first one as well. Right? What is the second blunder? The second blunder is, having written the lengthiest constitution in the world, we have not read it. And you may ask the question, how can you come to the conclusion? I think that's why I asked the first question, how many of you read the constitution at least once? Whether we understand, appreciate, that's a different story. Reading the constitution from the first page to the last page. Now, if you take the entire law students population in this country, lawyers population in this country, all the judges, judicial officers sitting and retired, if you just put all of them together, they may not even constitute 1% of the Indian population, that is 1.4 billion. Now, out of these lawyers, law students, and the judges, how many of them have seen the Constitution is the question I would like to ask, not how many of them have read the Constitution. Right? So, the proof is very clear. With the huge population that we have, we don't even have 1% of the population which is very clear as to the constitutional parameters, what is right and what is wrong. And therefore, we have left everything to the political representatives that we elect to do whatever they want. And the Supreme Court also started interpreting in that favor to a great extent, particularly after 1970, with the supersession of 3 judges of the Supreme Court, right? I think many of the judgments that followed, and I would appreciate if all of you read one judgment at least, right? Samsher Singh versus State of Punjab, 1974 Supreme Court. Please note down 1974 Supreme Court. It's a 7-judge bench judgment. And if you read that judgment and try to find what they have said, I hope you will not find anything in the Constitution. So therefore, and similarly, Keshavananda Bharati, which we celebrate the 50 years of the basic structure doctrine, right? When you don't understand what is important and relevant, we celebrate the basic structure doctrine to a great extent. So therefore, if you have not understood, how do you justify the preamble which starts with the phrase, we the people of India do blah blah blah, etc., adopt, enact and give to ourselves this constitution? Do we know what it is? Do we understand the implications? And as teachers, I think at least these law students, we should encourage them, study, make them understand the dynamics of constitution and constitutional law in a manner that they take some interest, start writing, right? Start doing some research in this particular area. I would also like to key in, maybe at the fag end of it, some important topics, or I'll post some important questions which will give you, if you are not doing your PhD or if you have not done your PhD, at least a topic on which you can do some meaningful research rather than simply looking into the constitution, the provisions, what the Supreme Court has said and it has not said, right? That everyone can do. So therefore, the quality of constitutional law is in your hands, right? Not in the hands of the Supreme Court. Supreme Court only interprets. And I think we should start writing and questioning the judgment of the Supreme Court by critiquing, not criticizing, by critiquing with reason as to why the Supreme Court, what it has done is wrong. I think there is a path of progress in this place. The third Himalayan blunder, which I have seen over a period of time, I think I have given you the hint earlier itself, that when you have the lengthiest constitution, written constitution before us, and whenever you go for interpretation on something, not on fundamental rights, anything in fundamental rights is welcome. But outside the scope of fundamental rights, when they try to interpret the Indian constitution and its provisions, they rely very heavily upon the British constitution, which is not even written, right? And therefore, the interpretation by the Supreme Court based on the unwritten constitutional practices of United Kingdom over the written words of the Indian Constitution is something very alarming, very misleading, and I think that is a place I would like to make you people appreciate what I am trying to tell you, right? So therefore, constitutional law is not simply speaking about what is contained in the book, but as teachers and researchers, you must go beyond and find out what is that we can contribute not only to the development of constitutional law, but also uphold the values of the Constitution and protect constitutionalism over a period of time. It is not simply the domain of the court. I think every citizen of this country has a moral obligation to do it. So once again, very quickly, what I have seen in the 75 years of our republic is the reflection of three Himalayan blunders. We wrote the lengthiest constitution. Having written, we have not read it. And finally, that written provisions of the constitution are interpreted by unwritten practices of England, right? I'll just give you very quickly one example because otherwise you will think that I am saying something in the air, right? I hope all of you must have heard about UNR Rao versus Indira Gandhi, 1975 Supreme Court judgment. A wonderful constitutional question was raised, right? And I hope I don't have to get into the facts of the case. The Lok Sabha was dissolved. The president requested the outgoing Prime Minister, that is Mrs. Indira Gandhi, to continue in office till the next Lok Sabha enters the office. UNR Rao, a senior lawyer who is no more, moved the Madras High Court seeking the writ of quo warranto. He asked a wonderful constitutional question. Under Article 75, there is a subclause, there is a clause which says the Council of Ministers shall be collectively responsible to the House of the People. Right? I hope you all understand that, isn't it? The Council of Ministers shall be collectively responsible to the House of the People. Now, his question was, if the House of the People has been dissolved, to whom are you responsible? I hope you got the significance of this writ petition. Right? The House has been dissolved. Now, the Prime Minister, outgoing Prime Minister, continues with her own Council of Ministers. And you say the Council of Ministers will be collectively responsible for all its acts to the House of the People. The House of the People is not there, right? Even the election is not being notified. So, which means they can continue to do whatever they want to do without the one and the only responsibility available in the Constitution for the Council of Ministers. There is no other responsibility. And that too, they are collectively responsible. And then something happened. I don't want to take much time. The background about the case, what transpired between the judiciary and the executive. Right? Ultimately, the Madras High Court wrote a very good essay on the British constitutional law and said in England, there is a convention. The convention is that when the Prime Minister loses the office, when the House of Commons is dissolved, the outgoing Prime Minister will continue in office. It is not true. Right? You must have seen the two changes that have taken place in the recent past, even in England. Right? Our own person of Indian origin, Sunak, became the Prime Minister. Right? And how much process that we don't follow all the good practices. Right? So therefore, the Supreme Court, the Madras High Court dismissed the petition by saying that in England it happens and therefore in India it is right. Right? But the High Court did not bother to respond to his question, how come the Council of Ministers will be responsible collectively to the House of the People for all their actions taken during this interregnum. Right? During the interregnum means after the dissolution of the House, what till the next House is elected and the Council of Ministers steps in, whatever they do, they are not at all answerable. Why? It is very simple. Assuming that the party loses the election, the Prime Minister will resign and go. Right? But will they be held accountable for whatever they have done during that period of 6 months or so or more? And I think that is a place where I think we need to look at the constitutional provisions, the safeguards that are provided, and therefore, right from the beginning, we have killed the office of the executive, the president and the governor. And 1973, they even constructed the tomb, right, so that they don't come out. And ultimately, we call them as constitutional heads. But if you read carefully the provisions of the Constitution, you will get something else and not what the court has said so far. Now, to tell all these things, if I just read Pandey, J.N. Pandey, or Mainini in constitutional law, or some notes, cyclostyle notes that's available, it's not possible for me to become critical of what is being said and what is being written. And therefore, if I want the constitutional law course to survive meaningfully, and do many more things than what I explained so far, we should have at least certain essential tools when you go to the class. Right? Now, when you go to the class, and once again, I would like to ask this question, how many of you take the text of the Indian Constitution with you? Right? And I think today, at least two leaders are carrying this text. One is the Prime Minister who keeps a big calligraphic, constitution and goes and worships. Right? The other, it is the leader of the opposition. He carries the same text, EBC publication, and says, you have not read it, you have not read it. Beyond that, I don't think whether they have read anything meaningful. So, I would appreciate all the teachers to make it a point and see the pleasure, right, of carrying it and reading the text of the Constitution inside the classroom. If Article 326 is questioned, Article 324 is questioned, you will also inculcate a culture among the students. Even if they don't carry, it's all right, nothing wrong in it. Because today we are teaching millennial kids who are very comfortable in digital display of these texts, and the Constitution is available in the digital form. Ask them to use a mobile phone. There is nothing wrong in it, right? Ask them to identify, check 324, ask one of the students to read the text, and everyone will follow. You will also follow. Then, when you read it number of times again and again, you will understand the dynamics, how we have swallowed many of the phrases in between and allowed the practices to continue even today. So, therefore, the first and the foremost tool, in my opinion, I know you may not consider is relevant, to carry the text of the Indian Constitution to every class you go, right? I don't carry my mobile phone, but if at times I have to go to some places, I also keep the text of the Indian Constitution in my mobile phone very quickly to read, question, challenge the views of the judges. I'll just give you an anecdote. I don't want to name the judge, a retired judge of the Supreme Court. We were all together in a conference on appointment and removal of judges, right? And it was in the last session, and I was the last speaker. He spoke first. A retired Chief Justice of Orissa spoke second. The Additional Advocate General, then Prashant Bhushan, and finally I was allowed to speak. All of them were speaking about appointment, all the dynamics. I don't want to get into it. And all of them also spoke about the not the removal, but they used the phrase impeachment. Impeachment of judges. Right? When I started addressing the gathering consisting of all lawyers, sitting and retired judges of the High Court, I told them, please don't consider whatever I'm going to say as purely academic, and whatever I'm going to say is purely constitutional. And I made a statement very firm that no judge of the High Court and the Supreme Court can be impeached. They were all, looking at me as if I have come from an alien world, right? Not a single judge can be impeached, but I paused for a second and said, but they can be removed from office. There is a world of difference between impeachment and removal, because under the Indian Constitution, only the President of India can be impeached. Nobody else can be impeached. They are all removed by the President from their respective office. Right? As I was saying, the judge took the text of the Indian Constitution from my hand, quickly referred to it, and stopped me for a while and said, what Professor Vijayakumar says is absolutely right. I have been there, I have done many things. I retired as a judge of the Supreme Court, but I keep committing this mistake of impeachment. Now I understand the implication between impeachment and removal. I'm just giving you one example. Like this, we have number of examples where our attention is diverted, the constitutional provision is totally violated, right? Second important tool that you should keep in hand is a standard textbook for reference. In the very first class, there is nothing wrong in telling the students, I am following, right, a particular author. It can be any author, I don't want to prescribe, right? It can be any author except J.N. Pandey and Maineni, right? Then only you will understand and appreciate the work that you are doing. It can be referred to. I'm not saying all the standard texts are correct, but even then, they are better when compared to this Maineni and J.N. Pandey. I'll give you a couple of references if you want little later, but one standard text you have to necessarily follow. The third important tool that you have to keep in mind is the relevant journal articles, because the books are published keeping in mind certain basic parameters, whereas the research articles published in journals are always critical. I hope you understand, and also contemporaneous, right? You may have a book published in 2022 or 2020, but these journal articles may be published in 2025 or just before you begin to teach this course to the students in your own institution. So therefore, collecting relevant articles on the themes that you are going to discuss is also third important element that every teacher should equip, so that you have a holistic perspective of what you are speaking or addressing. The fourth essential tool, in my opinion, is the judicial decisions, right? And the judicial decisions not given in the books or in the journal articles are the head notes of those decisions, right? I think as teachers, we should spend some time in going through the full judgment. Of course, it is taxing, because the recent judgment that the government of Tamil Nadu versus governor of Tamil Nadu is almost 404 pages judgment, right? So if I have to sit and read it for one particular aspect, why should I read it? But I think it is worth reading because it also involves connected articles, connected interpretations, the precedents given by the courts, so on and so forth. So therefore, the reading of complete judgment in full, not only the head notes, will make us understand the Constitution and the constitutional law better. Because there are statutes that are being challenged, and the validity of these statutory provisions through the constitutional provisions, either they are declared valid or invalid, and therefore we need to do that. And that makes constitutional law, graduating us from constitution to constitutional law. The fifth important tool, I may keep on adding to it, but for the time being, I would like to stop with this. The fifth important tool is comparative perspective, right? Now, what is this comparative perspective? If I am reading this judgment, or let me just refer to a fundamental issue raised, and it took almost 44 years for the Supreme Court to come to the conclusion, and that too in S.R. Bommai versus the Union of India, that the Indian Constitution is federal and federalism is a basic structure, right? It took 44 years for the Supreme Court to say so. Till that point of time, we were doubting because we use the term quasi-federal. It is more unitary, right? I don't think people can understand and appreciate either it is unitary or federal. There is nothing called as in between, right? Quasi-federal is not a phrase to convey something. Ours is as federal as American Constitution, right? Dr. Ambedkar, on the last date, 25th November 1949, when somebody asked this question, he said our constitution is purely federal. Because they were referring to Article 1, India, that is Bharat, shall be a union of states. The term used is union, right? And therefore it is not federal. But Ambedkar himself said it is federal. Professor Burgess of the American, one of the leading universities, if I remember right, Temple University, and through him, Ivo Dukashek, in his comparative constitutional law, very beautifully says, even if there is one single power in favor of the state, it is federal. Please try to understand. Even if there is one single power in favor of the states or provinces, it is federal in nature. And whereas in India, we have how many? 66 subject matters in list 2 of the constitution, 47 concurrent list on which both center and states can legislate, right? Again, don't you think these are all powers? But we did not understand this just because Granville Austin, some Western writers have mentioned that it is quasi federal, and we followed this as quasi federal throughout for our own convenience, which, in my opinion, finally got settled when Bombai's judgments came. They said it is a basic structure of the constitution. From nowhere, all of a sudden, it has become a basic structure of the constitution. What a transformation, right? Now, the comparative perspective, I'm just looking at it, is you can also refer to, if you can just log in and then check the preamble of the American Constitution. If you have a mobile phone or a laptop, please read, check a preamble of the US Constitution. It will appear in less than few seconds, right? And if you read that, we the people of, if I remember right, I may be wrong. If I remember right, we the people of the United States of America, in order to, am I right? In order to, what is that language? In order to realize our object, I don't know, a more perfect union.
In order to form a more perfect union,
In order
establish
to
justice.
form a more perfect union. Now,
Yes, sir.
union, now what does it mean? Now, the Indian judges, Supreme Court or High Court, they all say that American Constitution is purely federal. Then why did they use the term union there? Right? Or is it a crime in Article 1 that we have used? India, that is Bharat, shall be union of states. It is for nothing but to realize, achieve a more perfect union. That union is federation. So, unless and otherwise, you have this comparative perspective, right? And therefore, today also, the president has referred a matter, right, under Article 143, based on the judgment given by the Supreme Court in this state of Tamil Nadu versus Governor of Tamil Nadu, right? Unless, what is meant by withholding the power? I'll come to that. So, therefore, in my opinion, if you want to be a good teacher, reasonably a confident good teacher, right, you allow the students to question, and to do that, these essential tools are mandatory for you to keep in mind, right? Otherwise, I don't want to take a particular topic and discuss this is constitutional law, right? Nobody told us, nobody taught me as to how you have to teach constitutional law. But I was lucky to be taught by a couple of doyens. And then I also worked in National Law School, and we had all devils, right, with the knowledge, where they used to question each and every statement that we make. So we were fortunate enough to go beyond and understand the Constitution in its full dynamics rather than being bookish, right? So therefore, these 5 tools, please keep that in mind. Now, let me just come to reality. Today, in the 21st century, when you are teaching millennial kids, whether it is in the National Law School or any private university or a college, wherever you go, it is not an easy job to teach any subject to the students at all. Why? Because they don't have the focus, right? They don't have the interest in anything, whether it is constitutional law, international law, whatever it is. 10 minutes they will listen to you, and then they'll take their mobile phone and then start meddling with that, right? So therefore, it is very, very difficult. I can understand. I have also gone through this, misery. But you have to find your own method of keeping them, right, interested in the subject matter. And therefore, you should also play certain games which these people will understand and appreciate. right? Take for example some uh, evaluation based on certain applications, right? Gaming platform they say, and I always say Kahoot is really wonderful, right? And then if you use that every week, whatever you do, conduct a small test on the last day in the week, or 1 week you teach something and organize a test based on Kahoot. You don't have to sit and value, because once you give the answer, automatically it reviews. Even if you have 500 students, it will give you the output and you can discuss. And that is how you have to play certain games to make the students to take some interest. And if you win over 20 to 30% of the students in that process, they will tell their juniors, the number will increase to 30 to 40%. They will tell their juniors, right? This teacher is really good, right? Don't wag your tail, listen to them, right? Then slowly but steadily, you will have obedient classroom, more than 60 to 70% of them coming there to listen to you. It's a hard work. It's not going to be pretty easy, right? So therefore, the challenges include the students that we get, the millennial kids, and they don't want to read anything physical, right? They all want digital copies of it, right? It's all right. You give also digital copies of either the books or the articles, the judgment. Ask them to read and come. Still, I find about 10 to 20% of the students are really interested in learning. And I think if we can inculcate confidence in them, that 20% can flourish into something higher to 50 to 60% later. Second thing is, if there is a judgment delivered during the process of teaching, now even if it is lengthier judgment, 200 page, 300 page, please read the full judgment on your own and ask the students and divide the students into 2 3 groups. Ask them to read on one particular issue, come back and discuss in the classroom. I think you will make the classroom really a place where you can interact with each other, learn from each other, clarify the doubts that you have. All these things are possible when you read the full judgment in context, which is contemporaneous. And I think you don't have to print and give. You tell the students, this is the first issue, some 3 or 4 students can look into. Second issue, another 4 students. Please come back maybe after a week when you read the judgment. We'll discuss this in the classroom. So you create some amount of interest in the minds of the students. It is very difficult to teach anything to the students in the present world because they have more information than what you have on hand. Right? ChatGPT, right, can give more information. Therefore, your job is to challenge that more information and convince them that the information is wrong information. I hope you understand what I'm trying to tell you. They have more information because they can collect this information from the internet. But you have to prove that the information that they possess is not the right information, right? And for which you have to work a little harder. And once you do that, then possibly, Brezhnev during the perestroika in Russia made a beautiful statement in international relations. And I would like to use that for the contemporary digital revolution that we see in the classroom. What Brezhnev said was, trust but verify. Trust but verify. So you also trust the information available in ChatGPT, but also verify. Right? So therefore, this is also very important to use the tool necessary and make the class little more interesting. The fourth is failure to develop critical thinking. I already mentioned, so I don't want to, waste more time on this. I hope everyone understands. And the last one, once again, I have mentioned, we have given more focus on fundamental rights rather than the other part of the Indian Constitution. Therefore, for us, constitutional law is fundamental rights. Right? I hope, as I mentioned, we have to stand up and salute the Supreme Court for the exposition they have made. But I think that's not the end of everything, right? So I would like to mention very quickly in the next 10 minutes, and maybe I'll ask if you need any clarification from a presentation for the next 5-10 minutes or so. There are certain contradictions present in our constitution, and as I mentioned to you, if you have not done your PhD, one of these areas can also be taken into consideration as an area for research, right? The first and the foremost, right? The written provisions of the Indian Constitution and the practices followed are different. So, therefore, it raises doubt on the written provisions of the Constitution itself, right? The first one is, even after 75 years, even after almost 30 years of Bommai's judgment that federalism is a basic structure, we are not sure whether we have a federal structure at all or not, right? That's what we see in the day-to-day working, right? The financial transactions between the center and the states, the laws made by the center imposed on the states, right? On many occasions, we feel that whether our constitution is federal or not, right? But I think that's a challenge which will keep the constitution working. The second one is the Supreme Court again took roughly around 23 years, right? And all of a sudden, in Keshwanda Bharati, 4 judges of the 13 judges mention that separation of powers and checks and balances are basic structures or essential features of the Constitution. Now, after that, right, we have passed another 52 years or 50 years. Now we are celebrating 50 years of Keshwanda Bharati. We really don't know the meaning of separation of powers, right? So this is the question that you continue to ask the students. What does it mean? And therefore, the 5 year students will go back, read Montesquieu, come back and say whatever they have read on separation of powers, right? And now, whether we have separation of powers at all, even in 2025, is a question because the executive is nowhere in the picture. And we conveniently call the Prime Minister as a political executive. I don't think the Constitution refers anywhere the term called as political executive. There is only one executive. If you want, please refer to Article 53, right? The executive power of the Union shall be vested in the President. Shall be vested. Who is vesting this executive power? The Constitution is vesting this executive power in the President, right? So, what is vested in the President has been divested by practice, by judicial decisions, and the way they select the presidents over a period of time. And that is why we have a president who is present, who is omnipresent everywhere, but not in a position to see any power being exercised. So, therefore, separation of powers possibly today is a tussle between the government in power and the Supreme Court, nothing else. So, therefore, we need to understand what is this meaning of the separation of powers and checks and balances, right? Even